This brings us to the topic, ever more complex, of legality. Legality is the state of the contracts having a legal purpose, right? It's the fourth requirement that is necessary for a valid contract to exist, right? So a contract to do something that is prohibited by law or to commit a tort, right? These contracts are not going to generally be enforceable, right? So if we were to decide to form a crime syndicate to smuggle contraband, right? That agreement may in fact be enforceable using our goons, right? But we can't go into a court of law and then argue that, hey, she, violated our crack distribution agreement, so we've got to, sue her for damages, right? That's not possible, right? But there are other situations that are going to be a lot less clear, so we need to explore those as well. For example, some contracts might be contrary to statute, but may not go against a straight prohibition, right? Some statutes set forth rules that have to be followed, or terms and clauses that have to be included or which are prohibited in certain contracts. They may prescribe different subject matter of contracts, or have other obligations that are imposed on the parties based on the status of the party or the nature of the contract. For example, the statute of frauds, which requires some contracts to be in writing to be enforceable, is a matter of, in a sense, legality. So let's look at some examples of contracts that are contrary to statute. Again, with contracts to commit a crime, we know that those are simply just going to be void, right? It's a direct violation of a prohibition. Some contracts that violate prohibitions, though, may be treated a little bit differently. For example, let's talk about usury, right? Usury is a category of interest that exceeds a statutory maximum, whatever that statutory maximum is, X%, right? So if you were to have a loan shark type contract that had a usurious interest term, these contracts are illegal, but they're not necessarily going to be void, because that would result in unjust enrichment for the party that receives the loan. So what the court will generally do is cap the interest rate on the contract to the statutory maximum that's permitted within the jurisdiction. This has the effect of reforming the contract. It also has the effect of imposing a term onto the parties that they did not originally intend. So this is a case where, even though the contract itself goes against a statutory prohibition, it is not a contract to commit a crime, so it's handled a little bit differently. Gambling contracts. States have traditionally deemed illegal gambling contracts to be against prohibitions against gambling. For example, if it's not a state lottery or a state-sanctioned gambling contract, they would be regarded as void, right? However, most states tend to regulate some form of gambling, and so some form of gambling contract is actually legal. But even in those states that permit gambling contracts, courts may often find that certain gambling contracts are illegal. The next category that we should talk about are the licensing statutes, right? Like driver's license, except for those that impact contracts, right? In many professions, like physicians, lawyers, accountants, etc., there are requirements for licensing, right? You have to have a medical license to practice medicine. You have to be a member of the bar of your state, which is, to have a license to practice law, and so on and so forth, right? These are not the only types of licenses that are granted. There are also licenses such as certificates of occupancy or other types of municipal licenses that attach to commercial businesses, all right? So let's suppose that you violate a licensing statute. Whether that contract is enforceable or unenforceable is going to turn generally on whether the intention of that licensing statute is to raise revenue or to protect the public. For example, if you come into my office and I pretend to be a doctor and I operate on you, right? The purpose of me obtaining a medical license is to protect the public from the unlicensed practice of medicine, right? I would not be able to take you to court to enforce that contract for that surgery, right? However, many other types of contracts simply have a revenue-raising function. Business licenses and so forth, occupancy licenses and so forth. These are generally taxes that are for the purposes of raising revenue. The contract is not going to be unenforceable for that purpose, generally speaking. But again, if the purpose is to protect the public from the unlicensed practice of a profession, that contract may not be enforceable without that license. So, by way of example, the United Arab Emirates once held a competition to establish the design of a new embassy in Washington, D.C. Elena Sturza, she was a Maryland-based architect. She was licensed in Maryland, but she was not, however, licensed in the District of Columbia. She won the contract. She exchanged proposals with the UAE offices, but they stopped communicating with her before the parties had an official signed contract. Later, she learned that the UAE had contracted with a District of Columbia architect to use another design. So she filed suit because she won the unilateral offer, right? And established a unilateral contract to her mind. However, her argument was interesting. So she argues that the licensing statute should not apply to architects who submit plans in international architectural design competitions, right? However, licensing requirements are necessary to ensure the safety of the public. It's one of the most important areas of licensure, right? So because she was not licensed in the architect in the District of Columbia, she can't recover on a contract to perform architectural services here, right? So it's an interesting result to that case. How would you avoid that? Well, you'd probably, when you submit your plans, submit them through a partner who is licensed in the District of Columbia. And our next area in the next video will be contracts contrary to public policy.